Thank you very much. Ms. Eiffel, I'd be grateful if you'd help shed some light on this. My view is that as a co-sponsor of the Voting Rights Amendment Act, it does have a nationwide impact, and it does take up the challenge of Shelby County in crafting an appropriately modernized formula. Pre-clearance is still necessary. I think this conclusion is demonstrated by the city of Evergreen, Alabama, which was recently bailed into preclearance under Section 3C of the Voting Rights Act for just the sort of discrimination that the Shelby County majority concluded the nation is largely free from today, I think incorrectly. Why isn't Section 3C bail-in sufficient to identify jurisdictions for which preclearance is appropriate? And what is the scope and reach of the formula proposed in the Voting Rights Amendment Act?
Well, let me return again to the nationwide application of this law. This is becoming something of a bait and switch. The Supreme Court's decision in the Shelby case was very much focused on the idea that you could not mark certain states based on data that the court thought was too old. And the court said that we needed current data based on current needs and invited Congress to draft a new formula. There is now a new formula. That formula requires the focus on current data and current needs by creating a rolling formula that looks at the prior 15 years. It does not look at the prior 15 years for any particular one state or another. It covers from New York to Florida. Every state and every local jurisdiction is covered by the same formula. As I said earlier, we simply can't wipe out the past. If a state in the past 15 years has violated the law, then those violations count towards that 15-year requirement. And if Texas happens to be one of those states, that is because Texas violated the law, not because the United States Congress is targeting Texas. The second thing I would say about preclearance, and you raised the city of Evergreen, which I spoke about, I think, before you came in, the current bail-in law occurs after litigation. So it's the same issue of having to find the case, find the resources, litigate the case, and then bail-in is a remedy that a court can order. Bail-in is always limited to the particular kind of challenge and the findings that the district court made in that case, and limited in time as well. I find it disturbing, and I think that all of us should, as Americans, if we are premising the idea that the protection of the right to vote should be based on the ability to find a lawyer and file a lawsuit. This Congress was given the sacred obligation under the 14th and 15th Amendment to the Constitution to protect against voting discrimination. And Congress, in the Voting Rights Act, has created a network of ways in which that protection can happen. One way is Section 2, which, when it occurs, can be quite effective. But another way is Section 5, which is preclearance, designed to avoid the difficulties of litigation and to get at discrimination before it happens.
Ms. Eiffel, if I might, on one other point, it's been suggested by some today that this bill doesn't reflect compromise, that it's frankly a liberal wish list that includes every possible remedy that the left might be seeking, and that it isn't the result of compromise. I don't see that as accurate, but could you help fill in some of those details?
Well, in fact, that's true. There was reference earlier to voter ID laws. This bill, frankly, assiduously walks around voter ID laws. It does not count denials of preclearance of voter ID laws. It does not count findings under Section 2, a Section 2 violation of voter ID laws, as a violation that can count towards the 5 or the 3 for preclearance. What that means is that only findings that a voter ID law was created with the intention of discriminating against minority voters can count towards a jurisdiction's violation. And I would hope that everyone in this room and in this country would be deeply concerned about a finding by a federal court that a voter ID law had been created with the intention of discriminating against minority voters.
A last question, if I might, to Reverend Dr. Johnson. We are meeting today in a Senate building named for Everett Dirksen, Senator of Illinois. And I think anyone who knows their history knows that he played an absolutely central role in the enactment of the 1964 Civil Rights Act. In fact, I think one of the things of which the Republican Party has long justifiably been proud is the central role that Republican legislators played in the enactment of landmark civil rights legislation in the last century. Yet today we seem to see a partisan divide on this Voting Rights Amendments Act when previous VRAs had been broadly bipartisan in their support. Why do you think that this has become a partisan issue?
Very good question, especially considering the fact that every reauthorization of this important act has been by a Republican president. This should not be a partisan issue, the right to vote. And it is sacred, as Ms. Eiffel suggested. It was paid for with the blood, sweat, and tears of so many. But there's a larger historical point that needs to be made. If the Voting Rights Act is not modernized, then you are effectively ending the second Reconstruction of this United States. And there's a reason in Georgia why we have to put an asterisk beside the names of elected representatives. We say they are since Reconstruction. We have been here before. After Reconstruction, across the South, over 625 persons were elected to Congress, including Jefferson Long from Macon, who was the first African American to speak in this Congress as a representative. And so how do you get from 625 after the Civil War, during that period of Reconstruction, you get there through federal protection. And when that federal protection was withdrawn, then those elected representatives disappeared because of the persistent nature of race as a problem in this country. And so we are seeing extraordinary success under the Voting Rights Act. I am here today to say, let's not take away what has worked so well. Let's keep it in place so that we don't repeat the mistakes of history and go down a pathway that I think is quite dangerous.
Well, thank you. The day that we announced the introduction of this bill, I was proud to be joined by Republicans from the House. I continue to hope and pray that we will be joined by Republicans in the Senate in what I think is the result of compromise, responsible and reasonable, but absolutely essential response to this difficult case, the decision in Shelby County. And I think modernizing, strengthening, and implementing an updated Voting Rights Act is absolutely essential for our nation. Thank you for your testimony. Thank you, Madam Chair.